Hello everyone. In this video, we are going to understand or discuss a case study related to discipline. After looking into the case study, the individual is able to analyze the given situation or the case, and he is able to come up with his solutions. Let us see the case study. The case is like this. So this case is basically about a domestic inquiry that has happened in one of the factories due to an issue of misconduct from an employee's side. In a medium-sized engineering factory, the management intends to take disciplinary action against an employee who has been a habitual latecomer and pays little heed to his supervisor's repeated directives. So here is an employee who has been habituated to come late to the office, though his supervisor is continuously giving warnings. He is not listening to his supervisor. So the situation has come at one point of time. The management has decided to take action against him. And this time also, he comes late. And when protested by the supervisor, he refuses to answer. And moreover, he uses offending language against the supervisor. So, because of these things, the supervisor identified the acts of this employee under misconduct. So, this misconduct concept is highlighted in Employee Standing Orders Act 1946. So, these acts constitute misconduct under the standing orders in operation in factory. So the management decided to issue a charge sheet asking the employee to show cause or to give why to give explanation why management should not take an action against his act. So the management then issues a charge sheet asking the employee to show cause why disciplinary action should not be taken against him for offense. So the employee gives his reply and his explanation, but the management is not convinced with the reply of the employee, and it feels that the reply is not satisfactory. So it decides to proceed with the further action, that is the conduct of domestic inquiry. And as a part of domestic inquiry, management entrusts this entire inquiry tasks to one of the supervisors in other departments. So one supervisor from other department, he has been entrusted as the inquiry officer. The inquiry officer does not question the erring employee. So the moment this inquiry officer took the charge, he did not ask any questions the employee, and instead of that, he relied more on the employee's past records in terms of performance and behavior, and he obtained information through fellow employees and the workers who are in the rival unions. and some leaders in the rival unions. So the inquiry officer does not question the erring employee. So we did not encounter the employee to get the information. Instead, he relied on the past record of the employee, and he got information from other department uh, people, and he got information from the supervisor who gave complaint on him, fellow workmen, and some leaders of rival unions. So after collecting this information, he completed the inquiry in a hurry manner within short span of time, and he submits the report to the management. So basing on the information given by this inquiry officer who was appointed uh, uh, from other department, the management identifies this employee as uh, identified with guilty. So he was caught under misconduct and recommends for the dismissal. So the competent authority of the establishment endorses the recommendation of the supervisor conducting the inquiry. It acts as the inquiry officer's report, and it dismisses the erring employee. So here comes the problem. So the employee who was dismissed from the work on the grounds of misconduct. So he went to the, he is not satisfied with the decision taken. So he is aggrieved by the decision of the management. So this employee goes to tribunal court, and he manages to get the matter referred to the tribunal court. So he goes to the tribunal court as per the provision under Industrial Disputes Act 1947. So after taking this issue by the tribunal, it found that the domestic inquiry conducted by the appointed person by the company was not properly done. So it cancelled the order given by the management about dismissal, and the tribunal recommended the lighter punishment to the uh, employee who was caught under misconduct. So the punishment that was given to him is withholding the increments and as well as promotion. So this is about case. So the case is about an employee who is coming late to office, though receiving warnings, not listening to the manager, finally uh, dismissed from the job on the grounds of misconduct proof. But the employee is not satisfied with the dismissal. So this employee goes to the tribunal court to get the judgment fair. So the tribunal looks into the issue and finally decides to cancel the management's decision of dismissal, and it recommends a lighter punishment like withholding the increments and withholding the promotions. So this is about a case and the facts of the case, a situation where the case has happened. Now let us see what are the uh, questions that are given under this case. So the first question is, has the inquiry officer followed the principle of natural justice in conducting domestic inquiry? As the inquiry officer followed the principle of natural justice in conducting the domestic inquiry. So if we see the concept of discipline, when an individual is caught under misconduct, so if the information or the explanation given by the employee is not satisfactory to the employer, then he goes to follow or implement a system of domestic inquiry. And in domestic inquiry, a clear procedure is explained. So as a part of that, this word called natural justice should be certainly followed by the inquiry officer. In the given case, the question is like whether the inquiry officer followed the principle of natural justice or not. Now, if we see this principle of natural justice, this concept is enshrined under Article 311 of Indian Constitution. So this principle of natural justice is there as Article number 311 in Indian Constitution. It says that no person shall be dismissed or removed from service until he has been given a reasonable opportunity to show cause why the proposed action should not be taken against him. No person shall be dismissed or removed So this principle says that no person shall be dismissed or removed from service until he has been given a reasonable opportunity to show cause why the proposed action should not be taken against him. And in the given case, the inquiry officer did not follow the principle of natural justice because he did not interview or he did not call the employee, and he did not ask anything the employee who is caught under misconduct. So he did not collect any information from the employee in any manner. Instead of that, he relied on the records, past or previous records of the employee. So that's the reason why he did not listen first to the employee. So directly, instead of listening, he relied on gathering information from the previous records, gathering information from the people who gave complaint on him, and the leaders of other trade unions. The second question is, was it proper to entrust the task of conducting domestic inquiry to a supervisor rather than to an officer of the establishment? So the question is, was it proper to entrust the task of conducting domestic inquiry to a supervisor rather than to an officer of the establishment? As per the domestic inquiry process, management should appoint an officer of the establishment or an outside neutral person to hold the inquiry, and the same is intimated to the concerned persons accordingly. So as per the domestic inquiry process, management should appoint an officer of the establishment or an outside neutral person who can do this process. But if we see in the given case, instead of giving appointing an officer of the establishment, the organization has relied or appointed a supervisor from other department, and he was entrusted and given the responsibility of uh, understanding the case. So I generally it is it is not accepted, or it is not good to entrusting a task to a supervisor from other department, where the process is clearly telling that the inquiry process should be given to an officer of the establishment. So it is not proper. The third question is like, on what grounds did the tribunal hold that the domestic inquiry was not properly conducted? If we clearly see, the employees' voice was not heard by the inquiry officer first. Second one, information was collected from the supervisor who complained about the employee and the fellow workers and the leaders from rival unions. So these are the sources where this inquiry officer gathered the information. In such a case, he may not get sometimes the accurate information. So these things may be the reasons where the tribunal came to an opinion that the domestic inquiry process was not done properly. So the reason why this tribunal felt that the domestic inquiry was not conducted properly is employee's voice was not heard by the inquiry officer. Information is collected only from the supervisor who complained about this employee and some fellow workers and the leaders in rival unions, and the information related to the employees' past performance and past records. These are only considered by the inquiry officer to identify whether he is caught of guilty, is proven guilty or not. So the tribunal might have felt that this information is not accurate and sufficient to take a decision about the employee has done wrong or not. So these are not sufficient to give clear picture of the situation. The next question is like, can the management's decision to dismiss the employee be challenged before a tribunal constituted under the Industrial Disputes Act 1947? Definitely yes. The word called discipline is given, or issue of discipline is given in 3 acts when we study the concept of discipline. One is Industrial Disputes Act 1947. Second one, Employee Standing Orders Act 1946. And the third one is Discipline Issue Underpayment of Wages Act 1936. When the individual who is caught under misconduct as per the Employment Standing Orders Act 1946, when he was dismissed, terminated on the grounds of misconduct, if the individual is on the issues of discipline, if the individual is not satisfied with the decision taken by the management, so that issue can be dealt, that discipline issue can be dealt under Industrial Disputes Act 1947. In such a case, the individual is empowered to take his to take the aggrieved can take the verdict of the management. He can apply to the tribunals about the verdict given by the management. So as per the ID Act 1947, labor courts and tribunals are empowered to solve disputes related to application and interpretation of the standing orders that are mentioned in second and third schedule of the Act. So the question is, can the management's decision to dismiss the employee be challenged before a tribunal constituted under the Industrial Disputes Act 1947. Yes, as per the ID Act 1947, labor courts and tribunals are empowered to solve the disputes related to application and interpretation of standing orders, as mentioned in Schedule 2 and Schedule 3 of ID Act 1947. And another question is the tribunal competent to reverse the management's order of dismissal and award the lighter punishment to the employee? Yes. As per the Act, the tribunal is competent to reverse the management's order of dismissal in the given case. The reason is tribunal uh, finds that the domestic inquiry process that was conducted is not satisfactory and it is not up to the mark. So the tribunal in this case felt that the domestic inquiry process was not done properly and it was done like one-sided thing. So it rejects the management's decision of removing the employee. Instead, it suggests the employee's promotion and increments are withheld. So these are all different questions that are related to the given case. So the case is all about a domestic inquiry process that happens in the organization and the role of tribunals and labor courts and their empowerment under Industrial Disputes Act to solve the disciplinary processes.